Hey gang, Stephen Marshall, KYLandlordlaw.com, back with another update because the hits just keep on coming. After the governor signed his executive order last week on August the 24th, that was Monday, we got news on Friday that the Kentucky Supreme Court had issued a new order on evictions as well. So that's what I want to focus on today, and then circle back around to cover up some lingering questions from the governor's order and figure out how the two go together. So the Supreme Court's order from Friday does two very important things, and one that has probably escaped notice. First, the Supreme Court's order makes clear that CARES Act properties must continue to give 30-day notices to pay or vacate. Now, before that order, most within the legal community had assumed that the 30-day notice requirement for CARES Act properties had expired, and that at least starting in September, you could go back to giving your usual notice. Well, this new Supreme Court order reinstitutes the 30-day notices for CARES Act properties. So that's in addition to and beyond what the governor has said. Okay, so regardless of what any person reads the CARES Act and thinks, when you look at the Kentucky Supreme Court's order on evictions, if you're a CARES Act property, you still have to give a 30-day notice before you file an eviction, and that's in addition to anything that the governor has already said about notices. Okay, so that is going to escape most people's notice, but CARES Act properties, you're still at 30-day notices to pay or vacate regardless of any other order and in addition to any other order. Now, this was the next thing is the kind of the big boom that was from the Kentucky Supreme Court notice. Effective September 21st, it changes the court process for non-payment of rent eviction cases. And really what it does is just expanding the Jefferson County Eviction Diversion Program throughout the entire state, and it creates an even greater delay in the process. So here's the new process, all right? First step, just like normal, we're going to file an eviction complaint in the verification form, the AOC 1027 form, as usual. That hasn't changed. Second step, the court's going to schedule a court date, as usual. That hasn't changed. Third step, at the initial court date, both the landlord and tenant will be informed about local funding agencies that may have rental assistance to cover the unpaid rent. Okay, now that is new. That's not been happening statewide. That's going to start on September 21st. But here's the other and the important part. At that initial hearing, unless the tenant fails to appear, unless the case is dismissed by the landlord, or unless the parties reach a settlement agreement, the matter is then going to be postponed for 14 days. And a new hearing will be scheduled on the next available court date that's at least 14 days away. At that second hearing, the matter will be heard and judgment will be considered by the court unless a jury trial is requested by the tenant, and the tenant can request a jury trial at any point during that 14-day period. Okay, so things are going to be delayed significantly. Two things for you to keep in mind on this new process. It only applies to cases where non-payment of rent is the only basis for the eviction. It does not apply to other types of evictions, whether for rules violations, non-renewals of leases, or cases where non-payment of rent is one reason, but rules violation is another reason. Okay, those cases will proceed at the initial hearing. So this only applies to cases where the eviction is only based on the failure to pay rent, which of course is the vast supermajority of cases. The other thing to keep in mind, it doesn't start until September 21st. Okay, the question then becomes, does it apply to all cases starting on September 21st, those cases that are being heard that day, or does it only apply to cases that are filed on September 21st or after? From what I can tell after talking to a few folks, it's going to begin in all cases on September 21st. So when you show up to eviction court on September 21st, you can expect that this new process will be in effect. Now, That may not be the case in every particular district court in the state of Kentucky, but that's what I understand the process is going to be in a lot of places. As I hear differently, or if I hear differently, I'll let you know of that. But at this point, you should expect that when you show up on September 21st and you have a case that's based solely on non-payment of rent, you're not going to get a judgment that day unless the tenant doesn't show up or you reach some type of settlement agreement. You will have to have an additional court appearance starting September 21st. All right, so let's kind of circle back to the governor's order from last week because I had a few questions that kind of popped up after my last post on that. So first question, I issued my usual notice on August 16th. It was not a 30-day notice and did not request to meet with the tenant about the case. Do I need to issue a new notice? My answer is no, unless you're a CARES Act property. Okay, if you're just a conventional property, not a CARES Act property, no, you don't need to issue a new notice. The governor's office has confirmed privately that his order from August 24th does not affect cases filed or notices given prior to August 25th, the effective date of the order. So if you're not a CARES Act property and you gave your usual notice prior to August 25th, you should be fine. Even if it wasn't a 30-day notice, even if it didn't contain that meet and confer language. Now, if you're a CARES Act property, as I said earlier, the Supreme Court's new order requires a 30-day notice effective August 28th. Okay, no ifs, ands, or buts. 30-day notice to pay or vacate is required for CARES Act properties. Second question, this one's got everyone up in arms, and I certainly get it. I've been charging and collecting late fees. My tenant is requesting that I credit those fees to the next month's rent. What should I do? And I don't have a great answer on this. As the law currently stands under the governor's orders, late fees may not be charged from March 6th through December 31st of this year. Okay, retroactive to March 6th. Now, that seems to indicate that if you've charged those fees but haven't collected them, you need to reverse the charges. If you've collected the fees, it seems to indicate you need to credit that amount to the tenant's account. Now, whether you decide to do that, that's an internal decision. But the legal answer is, yeah, you reverse the charges and you credit any funds that have actually been collected as late fees. Now, look, nobody wants to hear that answer. And this issue is an absolute mess. As Chris Wiest explained last week on his Facebook page, the governor's order on late fees has basically made criminals out of every landlord who's collected late fees since March the 6th. Now, if you violate the governor's order, that is actually a criminal offense. It's a Class A misdemeanor, which is punishable by 90 days to a year in jail. Now, do I expect any county attorney to prosecute a landlord for collecting late fees? No, I do not. But it's at least something that has to be considered as you decide whether to credit late fees that have already been collected, because tenants are getting the word about this and they're putting those requests out to their landlords for credits for the next month for any fees already collected. So no great answer there because the governor's order is still law of the land. Now, hopefully not for very much longer, because there are two lawsuits coming up pretty quickly that could address and overturn the governor's executive order from last week and perhaps beyond. First, we had the Northern Kentucky lawsuit in federal court. We've discussed repeatedly in my blogs that several landlords up in Northern Kentucky and the Greater Cincinnati Northern Kentucky Apartment Association have filed a lawsuit against the governor in federal court in Covington, I believe, to overturn his eviction moratorium. Well, the landlords were allowed to amend their complaint to address the governor's new order on 30-day notices and late fees. And a hearing in that matter is scheduled for this coming Wednesday, September the 2nd. So keep an eye on that. The federal court there could overturn the governor's order on 30-day notices and late fees. We'll see what happens there, and I'll certainly keep you updated. Second, and probably even more importantly, the Boone County Supreme Court case. You may or may not be aware that the Florence Speedway A daycare center and a cafe up in northern Kentucky sued the governor in Boone County, alleging that his executive orders, all of them, were not lawful, not lawfully issued. And they're seeking to have all of those orders overturned and to require the governor to follow certain current legal procedures before issuing any new executive orders based on a state of emergency. Those plaintiffs won at trial. They won on the merits. At the Court of Appeals, they won on a procedural issue that the governor pushed forward. Now, what's left is for the Kentucky Supreme Court to hear the case. That's going to happen on September 17th, so that's 2 weeks from Thursday. The plaintiffs in that case and the Attorney General have both filed excellent briefs recently that I'm going to link on my blog. You can take a look at those. So that's going to be a very important case. We need to watch this case very closely because the justices of the Kentucky Supreme Court are elected officials. Okay, they're not appointed by the governor. They are elected officials, and they run on a nonpartisan basis. So for future purposes, you may want to know how the justice in your particular district voted in this case, because this case addresses some very big picture issues on liberty and the bounds of government authority. So I think we all ought to pay attention to how people vote, how the justices vote in that case. So I hope to be able to tell you soon that the governor's late fee order has been struck down, but it stands for now. Until that, as far as notices go, my advice is for all properties to give a 30-day notice to pay or vacate in accordance with the governor's order effective August 25th. And those notices should include the meet and confer language that he required to be included. If you need help with that, I've got a form that you can use that has the 30-day language, has the meet and confer language, and that is a $100 form. Just shoot me an email to smarshall@trippleslaw.com if you're interested in purchasing that. If you have any questions about these types of things, please reach out to your friendly neighborhood attorney. And I'll be back as soon as we have an update on any of this stuff. Until then, hope you guys are doing well, and we will talk soon.